Adam looks so serious.
All right, Dee, you may begin when you like.
Thank you so much, Jesus. Welcome to the April 6th, 2022 meeting of the CB6 Bylaws Committee. My name is Bee Disman. I am chair of the committee. This meeting is called to order at 6:33. Tonight, we're joined by District Manager Jose Perez. Members of the public, you may raise any questions or comments that you have through the Q&A feature of Zoom. If there's time following the committee's discussion, we will field questions from the public. We're still in need of a minute taker for tonight's meeting. So can I have a volunteer? We had Sandra do it, we had Adam do it. Who is volunteering tonight? Okay, Maura, I'm calling on you.
Yeah, that's fine. I've never done it, but I'll muddle
Yeah,
my way
there's a
through.
format that Brenda that
Yeah.
will get to you, and it's not every word. It's just a summary of
Yep.
stuff because there are transcripts and other things. Thank you. And I know that you all received an email from the board with a doodle sign-up sheet, but that seems not to be working. So we'll go ahead and do it at the meetings because I don't expect that we'll have more than a couple more meetings, to come together and present something. Okay, so we will now take attendance by roll call. Jesus, will you conduct the roll call?
Certainly. All right, committee members, when I call your name, please indicate that you are present. Beatrice Disman.
Present.
Adam Hartkey.
Present.
Thank you. Seema Shaw.
Present.
Thank you. Don Sherman is not joining us tonight, I understand.
He's excused. He's on a plane business trip right now.
Okay. Sandro Sherrod.
I am present as well.
Thank you. Maura Wong.
Present.
Thank you. Mark Thompson.
Present.
Thank you. And with 6 of 7 members present, you have quorum.
Thank you so much. Now we will talk about the agenda for tonight's meeting. It was distributed ahead of time by the board office and appears on the screen before you. If there's no objection, we'll adopt the agenda as stated. Members of the committee, if you object to adopting the agenda, you may raise your hand through Zoom. And Jesus is going to help me because I can't see hands. Jesus, I assume there are no hands?
None that I see.
Okay, then the agenda is adopted. Now we'll go on to the minutes. The minutes for January 31st and March 3rd committee meeting was distributed ahead of time. If there's no objection, we'll adopt these minutes as drafted. Members of the committee, if you object to adopting these minutes, you may raise your hands through Zoom. Jesus, I see none.
I see
So,
none.
the minutes, see no objection. The minutes for both January 31st and March 3rd are adopted. Let's set some ground rules. In order to conduct an efficient meeting, let's observe these rules. No one may speak until granted the floor. Committee members, if you have a question about committee business or wish to make a motion, please raise your hand through Zoom. The chat function should not be used for the committee business or questions about agenda topics. All such remarks should be made on the record by raising your hand through Zoom. Chat should only be used to alert us to any technical difficulties you are having or to state in writing information like an email address that already stated aloud on the record during the meeting. When a committee member is given the floor to speak, I will identify you. You can unmute yourself so that you can speak. We are required by New York State law to have a transcript of the meeting, so please keep your questions and comments succinct and germane to the discussion. Tonight's agenda, which you have in front of you, we can just take a look at it again.
Sorry, it went away. I'll bring it back.
Okay. Okay, so you see the order of the agenda as follows. We will start with discussion of bylaws, section 1 and 9 by Seema. Sean was supposed to do sections 5 and 8, but I think between the executive committee comments and you're all reading that, we can deal with that. There'll be a chair's report, old and new business. Under old business, I'm going to ask Jesus to talk about his research. We went and did research on the terms that the other community boards have for officers and when their elections are. And it was interesting data that I saw from Jesus, and I think he shared it with all you, how inconsistent and how community boards really don't even have specific bylaw statements. I guess I'm not surprised, but Manhattan was the best of them all. Okay. So Seema, if we can start with your first section, which is membership, and then go on to removal for cause. I thank you.
Sure. I am happy. How was this organized last week? Or Sandra, I guess, how did you do it? I can do the same thing, or I can just kind of dive in a different way, potentially.
So I think what we did, I'm sorry, is it okay if I answer, Madam Chair?
Yes, yes, you
Okay.
are. It was directed to you. You could certainly
well,
did. And
I
I
just
think
wanna make
the
sure.
technique that you did was the technique we should be following because it moved us really forward with the agenda. So get ahead,
So
Sandra.
I just went through, I think I shared the document and I went through some comments that I had made and also reflected upon the comments that were shared with us through Airtable, just as they came chronologically through the document. And I think we had a little bit of a discussion around the merits or the intent behind either the way it's written or the way it could be improved.
Okay, great. Thank you. Jesus, can I ask you to pull up the bylaws currently? And then I have like my own page of comments that I've made, so we can potentially look at it together that way. Is that okay, Jesus?
Sure, just give me 2 seconds.
Thank you.
I'm going to pull up the working copy that they were using last month so that I guess all the edits can be in just one working copy, if that's okay.
Yeah, Jesus, that's exactly what we should be doing because at the end, when we go through it all, we will actually go through that working document because we will have to expand some items and clarify some others. Thank you.
I also have this in a Google Docs. This is, I could share that directly with you if it's a little easier so you don't have to convert it back and forth.
No, this is a Word document that was sent to me.
Right, but I exported it, I think, from Google Docs, so I can share it like right now with you and Seema if you wanted to edit it in that format, but whatever works.
However you want to do it, and if you want, I can give you a permission to share your screen and you can just share it yourself directly if you want, but it's up to you.
I'll stay
Seema,
out
what
of it.
works? Seema, what works for you? You just want to start with this?
Yeah, I mean, we can start with this, and then what is the expectation? Like, should I be incorporating, my...
So what we agree upon, as items for changes, we're actually editing right into the document and showing that we're getting it. And we'll have one document with all of the various edits that we could then go through, make sure it's consistent because some sections refer to other sections. So we'll have one working document. That's what Jesus was talking about, as was Sandra.
Okay, so then, Jesus, would you mind editing, or if you want, you can, I can pull up this document and I can edit whatever works.
I can do that, or Sandro, you have the master document, I guess. Do you want to?
I just shared it with you and Seema, so anyone.
Yeah, I can just do it. It's yeah, not a
Okay.
problem. Not a problem.
I can share it though.
Okay, that would be great. And then I can open it here and then I can...
Right here. Could you just allow me to share, Suze?
Sure.
Let's see if I can make it bigger.
Sorry, I forgot. I thought you all had to.
Yeah. Okay.
Okay, there you go.
Which one is it? Looks like this.
Okay.
All right. So I started community board membership was one of my sections. Okay, so the first comment I had was in under A, all members shall serve on the board in their capacity as private citizens only. And a few members through the Airtable had also commented on this section. I think the tension lies in if we're private citizens only, then why are we recusing ourselves given our professional backgrounds? Like, that it should one negate the other. So if we're private citizens, why do we ever need to recuse ourselves? And so I think what this requires is like clarity on like what we're actually trying to say. And I don't exactly have like a potential recommendation, but I just wanted to bring that tension to the for conversation and see
Yeah,
if
so
others have any
Seema,
thoughts.
I underlined the word private when I went through it as well. And maybe we can talk about the intent. The intent is that we're not functioning in our professional capacity, but we're functioning as a citizen. That's the assumption I'm making. Does anyone else, as Seema, have the concern with the word private?
I don't have any concerns with the word private, just to clarify. I just want to say that if we are all participating in our full board and respective committees as private citizens, then there should be no reason to recuse yourself given a professional affiliation, because we're not supposedly, according to the bylaws, participating in any sort of professional way. And so I think it causes a level of confusion and doubt, frankly, because I know that we do have reasons why, given your professional background, like, for example, you have to recuse yourself from votes or from discussions and things like that. But however, if you're just participating as a private citizen, then does that not align? And let me pause. Actually, are people understanding what I'm trying to say in terms of the potential tension I'm seeing in this line?
Yeah.
Sandra?
Yeah, I think so. I mean, I can understand that it's maybe doesn't stand up on its own. I think the intent when it was originally drafted was a direct reference to the conflict of interest board guidelines that we have, but maybe is not reflected directly enough. So maybe we need to see if we can tailor some of the language that is required through the conflict of interest disclosure process, so that it's a little clearer the difference between private and the difference between why someone might have a vested interest, even though they're acting as a private citizen.
So I'm just going to comment. If you read the rest of A, okay, it really goes on to explain it. So when you go to the third sentence, and then I want anyone else comment, any member participating in the board's consideration of a matter who has a conflict of interest with respect whether involving a member's residence, property, business, employment, shall state the nature of the conflict by speaking to the issue and simply abstain. You could actually get to the same place by dealing with the conflict of interest issue. Mm-hmm. And I think, Sandra, that's what you were really talking about.
Mm-hmm.
Any other members have comments about this for Seema?
I'm just trying to state again, just if I'm not being clear, that if we are participating as a private citizen, which is what this bylaw is suggesting, then there shouldn't, I mean, again, unless it's like about my residence, potentially that or property.
So Seema, I think that there's two different things, right? So those of us who are working might not be technically representing our employer, but at the same time, the conflict of interest board requires that we recuse ourselves from that vote to prevent the appearance or any sort of chance of impropriety. Not.
Yeah, I mean, I've worked for the city. I've worked for the city and the state, and I recuse myself from lots of things too, right. All the time. Actually, frankly, especially in the business affairs and street committee stuff. But I just want to, I find it to be a bit confusing. I understand exactly. Yeah. I wonder if there's more language or more clarity, because if I'm only representing myself privately, then I am allowed as a private citizen to talk about, for example, a new licensing category that
Yeah.
potentially, eventually in my professional setting, might come to the agency that I work for. So I
Yeah.
just, is that clear? Because there is, so then I've always chosen to recuse myself, especially because it's something. So
Right.
for example, like all the casinos that are coming forward in the city, the proposals for casinos in the city would eventually actually have to come to the state. And in an abundance of caution, I've decided to not even participate in the conversation. But again, if I'm in my private capacity, then can I participate in the conversation?
Yeah. So,
So-
I
So
yeah,
I'm going to just say something, Sandra, now that you, because you know the conflict of interest issues. So I think with what the intent of this, and I wouldn't get hung up on the private citizen, because we do have to follow conflict of interest rules. So if there's a question about private citizen and stuff, we should really, I mean, the thing starts that membership shall be determined as provided by the city charter. Each member shall have the obligation and privilege set forth in city charter and bylaws. And then you can just actually go, any member participating in the board's consideration of the matter who has a conflict of interest, and just deal with conflict of interest. Saying private citizen doesn't really give you the whole
Mhm.
concept of interest.
I see. Yeah,
Sandra?
that's a good idea.
So-
Sorry.
Sandra?
yeah. No, but I think that's good. I was
Anyone
just
else?
going to call attention to the last clause of this very long run-on sentence about that. You're still, of course, welcome to speak to it, but
Mhm.
you're not. You should abstain when voting.
Yeah.
Maybe that could be clearer as well.
So I would recommend, and I can't see the other committee members, but I'd recommend deleting the first two sentences and just going any member participating. And I think conflict of interest is front and center in a lot of things now, and we need to be front and center with it. Does anyone have any objections or thoughts?
I have a question. Do we actually want to make some comment like, refer back to the conflict of interest board if there's any questions? Just
Yeah, I think
a
that's a
simple
good
statement.
idea. I think that's a good idea. So why don't we
And-
add a sentence like, any questions should be referred to the conflict of interest board?
And all members should be familiar with that document or those rules or
Yeah.
something.
Well, I have to actually ask the question, and I'll ask Sandra and Mark, because I think they've been involved more than I. I have never actually seen the conflict of interest rules. Have you guys seen it distributed on the community board?
We were technically required to sit in on,
Yeah.
I guess, training, they called it,
Yeah.
but they didn't distribute anything.
The conflict of interest board has like a strange. They put together a set of written determinations on different topics that are available, because every situation is fairly unique. So they kind of do a typical community board member response. But but any community board member or any city employee, in fact, who has a very specific concern can directly contact the conflict of interest board. And Mark and I both have done so as required in the past. So I think it's a good idea to kind of direct them to the authority on the matter, because this bylaw modification or the original is not going to really change the city's position.
Well, yeah, and you also have at our meetings, some people saying they don't know whether they should abstain for cause, abstain. And so there is some
Yeah.
confusion.
Some training there,
Bef-
yeah.
Yeah, before we leave A, any other committee members have any comments? Seymour, I'm giving it back to you.
Thank you. So for B, I looked through the Airtable comments. I think that people, the folks that commented had questions around what does exact wording mean? Like, if they use different terms to describe similar things, is that in violation of the bylaws? I don't feel strongly about keeping the phrase exactly as it is, which is through the exact wording of its adopted resolutions. But, I don't want to limit, the board chair specifically. I don't know if anyone had any thoughts, just raising it.
So this has come, and then we're going to turn to other members, and Jesus, you'll tell me who's raising their hand. This
Sure.
has come up to a number of comments and criticism. As a matter of fact, at the last meeting that we had in transportation, it was raised that the board makes policy by resolution passed by the board. And that is how we state things. So I think this whole question, it came up in the exec committee of feedback, it came up on this. What does exact wording mean? Is it just actually quoting the resolution? And the question is, you can't go beyond it if you're asked the question, how do you handle it? So I think it has the intent that a chair cannot make policy, but the resolutions themselves don't spell out everything if a question is asked. So I think this is the tension that exists. Seema, you saw the tension, but I think this is a very significant issue within the board. And it's been controversy when people have gone beyond that. Anyone else want to comment with their experiences?
Yeah, I'm raising my hand, sorry.
Yeah, that's okay. You have to raise it that way because I can't see anything else on my iPad. Yeah.
I mean, I think, that's an excellent recap of some of the issue. So there's kind of like 2 or 3 parts to this. So the first part is, I think we want to ensure that whoever is elected chair is accurately representing the intent of the board as a collective and not taking their own opinion and representing it as fact on behalf of the board, because the chair or their designee is often representing the board at borough board or other events and press conferences. So I think that's very important that they understand that they're representing all of us. But then the other part of this is the kind of the flip side, where a member, and we've had this many times in the past, we've had a member that will be quoted in a paper and issue their personal opinion on a matter that was before the board in such a way that was conflated with the board position and at times completely against the board's stated position. So I think it's an imperfect paragraph for sure, but I think that there is some clear delineation between someone expressing their own inferred reasoning or rationale behind a resolution and just expressing the resolution. I can say that as a chair, I believe in the past, when we write letters or when we write any sort of email for that matter, or have a phone call, we often have to refer to a resolution that was adopted by the board and then perhaps explain to another agency why this was adopted and the concerns around it. So obviously there has to be some actual verbiage around our stated positions that's not technically in the resolution, but we do need to figure out a way to ensure that they are not deviating from the intent.
Anyone else have any comments?
Just FYI, we do have a board member who is not on this committee, but was attended as a guest, Anne Seligman, who has her hand up and requests the floor. Would you like to give Anne the floor?
Let me see if there's any other committee members that has a comment, and then I will go to Anne. Anything else in the committee members?
I just raised my hand. Sandra, just to respond to what, or not to respond, actually, to seek some clarity from what you're saying. You're saying that this is not perfect, the language letter B as it's stated, but you think that the intent behind it is trying to communicate what you're hoping the board will follow. Is that accurate? Did I understand that correctly?
I think so. I'm speaking of both in like a former chair role as a member as well. I think that there's a duality to the protection that something like this offers, but maybe we can tighten the language up to make it clearer.
Okay.
Yeah, I see it as when it says not add or imply additional language. I have seen that in my time as the board, that people expand into areas that were never discussed at the board and going
That has
with
happened.
the person, which has happened. So the language here is pretty tight to deal with this particular reason, because those of us that have seen the experience. Anne, do you have a comment?
It seems like Adam Harkey had his hand raised.
No, you can
Okay,
go.
Adam,
No,
let's go to Adam first.
I was just going to echo what everybody else said. So in the interest of time, please go to Ann.
Okay, and
And you can unmute yourself.
Yeah, I submitted, I did submit this issue in the Airtable. My question is kind of a little bit, kind of the, almost the opposite of this, that I'm concerned that there are times when a response has to be done quickly with, you know, with the business affairs and licensing. That comes up a lot. And it also comes up like when the, you know, a ULURP comes up in the summer and we have to reply, you know, we have to respond. You know, Sandra, I know you've certainly dealt with this with, you know, land use and waterfront issues. So I'm just concerned that, you know, there are times when it's like we have to respond in a timely manner, but because we have this completely reasonable clause in the bylaws, I don't know how we also have the flexibility to respond when we need to quickly.
Yeah, I mean, I do. Can I just answer that really quickly? I'm sorry if I
go
just
ahead,
have two
Sandra,
thoughts.
and then I'm going to comment on that because that's
Okay.
covered actually in another section. Go ahead.
Yeah, I was just going to say real quickly, you know, I think this is one of the challenges of a deliberative body, right? It's not an executive, it's not a single point of opinion. And sometimes we don't get to an opinion in a reasonable time frame, even for our own timelines, let alone for other agencies. So that can be challenging. What has helped though is when the chair can provide commentary around previous similar resolutions. So while it might be a very specific question that city planning or you know, the state liquor authority is asking about, we can reference existing policy that is in line and say, well, based on previous discussions, this might or might not be possible. But yeah, it's very difficult to invest a actual determination or a policy making a power in someone in a deliberative body.
Yeah, and I mean, I did in my comments that went to Airtable, I did also sort of reference like 8H. Also, section 8H kind of addresses this.
Yeah.
So,
Anna,
you
can
know,
we
it's
go
like
to
maybe
that?
that covers it.
Yeah, I was going to go to 8H because of what happens during the summer. And, you know, you could provide us information, but I actually would be loath to do anything that pulls us away from this particular thing because we are a deliberative body. We are not speaking as an individual. And so we should maybe take a look at the language, but I think the language expresses that it's the board that makes policy through resolutions. And that's how the board really speaks. And having been a party to some past disputes about this, we can go down a road that really will not be very efficient or effective for the board. So I would recommend we'll take a look at the language to see if there's a way that we need to clear it a little. But this and referring it to the later article gives us the option during the summer when we talk about things that are passed by the executive committee and they're shown as information. We do have that at least during the summer months. So any other comments along here from the committee members before we move to the next one?
Yeah, so just one personal comment. This was not in the Airtable. It's my review. If you don't mind scrolling back up, you know, we say that the first line is that, you know, community board speaks through the exact wording of its adopted resolutions. I did want to ask the question. I know sometimes we've issued letters, we've done other, you know, we've made non-resolution statements. So I was curious if anyone thought we needed to kind of broaden beyond resolution, only because I know that we've, you know, made other comments through other means.
So let me see if the committee members has any comments for you, because I will reserve mine after to see if anyone else does, because we do letters. We
Yeah.
do.
Yeah,
go ahead.
I think I'll answer. I think that there's a difference between stating So if we're doing like constituent work, someone's complained that
Mhm.
there's a storm drain that's not draining, right? Reaching out to a department like DOT or someone else, I don't think is a policy making decision other than we have an existing policy of fixing broken utilities in our district. So in that case, I would not be concerned. But if it was a policy making thing where someone's actually asking us to make a determination of whether fixing storm drains is an appropriate thing for someone to do, then I think that's the realm of resolution and deliberation.
Yeah, so I was going to go, Sandra, where you are. Letters are coming from the community board on a lot of constituent stuff. It's like a congressional office where people come in and we raise issues, but we don't make policy in those letters. We use resolutions or pass resolutions for policy.
Yeah, and we have staff that have to, interact with other agencies. We can't hamper them from doing their jobs.
Yeah, and that goes to the part that
This is
I think
not-
bylaws are not operating laws, are not operating principles. You have to separate what I call a constitutional structure of bylaws from the day-to-day operations. And I would not look to put anything in the bylaws that would actually impact the day-to-day operations of an efficient office.
Yeah.
Okay. Seema, anything else?
Yeah, I would actually push back and say that we should then specify that we mean from a policy context, because the way it's worded right now, it says CB6 speaks only through the exact wording of its resolutions. That's not true, right? So we also
Right.
speak in many other ways. So I think we should change the language there.
Yeah.
Something. Okay, I'll make a note here.
Policy, something in there, yeah.
Yeah, so why don't we put in non-poli, let's play with some language afterwards. In, CB6, in non-policy areas communicates, through agencies. Well, let's put a placeholder and we'll come back with language, okay?
Okay.
Mm-hmm. Sounds
Okay.
good. I just
Anyone-
added, oh, sorry, go on.
Yeah.
I'm sorry, go
Not-
ahead.
I just want to know if Adam or Maura have any other comments?
I'm in agreement.
Okay, I assume Adam, you're also?
Yeah, none for me.
Okay, go ahead, Seema.
I just added in letter C now because I felt like that added in a new concept. So that's just my reordering right now. But
Okay.
basically the clause says that, again, you cannot add any additional words or language or imply something, if you're talking to an elected official, public agency or the media, etc.
So you
I think this
separated, it out, so we can take a look at your draft.
Yeah. Oh, I do want to know, I'm just referring back to the Airtable. I do want to note that there was a comment in there that said, do we want to specify that this is like only that the chair should speak on behalf of the community board? Sorry to go back to the first one.
Yeah, so I'm going to comment because the bylaws allows the chair to have someone else speak.
Mhm.
And the chair has authorized other people to speak. And I don't want to take the flexibility from the chair. That becomes too hierarchical. I don't know if anyone else disagrees.
I agree.
I agree, but I was just going to again point to the last portion of the sentence, the clause that says may add words to our resolutions or state or imply additional meaning. So it doesn't actually prevent people from anyone on the board from communicating board positions with elected officials. It just it prevents them from doing so in a manner where they're adding intent that might not have been there. Maybe et cetera with a period should be removed so that it is clear that that's not a contraction and in fact part of the same sentence.
Let's take out et cetera.
So it'll say no board member, blah, 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 may add to the words of a resolution.
Right.
Okay. All right.
Okay.
Any other comments?
No, I think this is a great ad. I agree.
Okay, letter D, any member appearing before, so here's like, I mean, I think there's no other way to address this. So basically it says, you know, if you are appearing in front of a governmental or private body in your private citizen capacity, you know, you have to say that you're not speaking on behalf of the board before making such a statement. But it's funny because there's like the question of like, if you're,
Mhm.
do you know, I'm having
Yeah,
a hard
like-
time.
Like you're talking about something, you shouldn't have to go, I'm talking about telephones, but not as a member of the board.
Yeah, yeah.
Let me
You
have
see,
you
I
do that.
disagree. I disagree, guys,
Because-
having testified a lot,
Mhm.
that you have to say that you're doing your own if it deviates from the board and deviates from resolutions, you're still allowed to speak as a private citizen. But because your name is affiliated with the board, they have to know that you're not there in the board capacity, but as a personal individual. This has been standard, whether it be Congress or council or whatever. I don't find it awkward at all.
But it's
Yeah,
funny,
I
it says that
agree with that,
only
Bea.
when, it says only when there's a conflict. So if there's no conflict, then you don't have to disclose that you're not speaking on behalf of the board.
It should be
Like it
whenever
says-
you're talking about a subject that's related to something the board has done.
Right? I actually, yeah,
I
I agree
see,
with you,
yeah.
Mark, but the way that it's written right now, or at least the way that I'm interpreting how it's written right now, is that when there's a conflict with board positions, you state that you're not speaking on behalf of the board.
Yeah, I think conflict in this instance is just any sort of deviation from an implied resolution or official statement.
Would it be more like
That-
relates instead of conflicts? Is that the right?
Yeah, I think, but then I think, was that you, Adam, who just said that? Sorry, I missed it.
Yeah, because I mean, like echoing on B's point, like you as a private citizen or member, you know, you can essentially say whatever you want, but you know, unless you're repeating verbatim an official resolution or some of the other official documents we referred to earlier, you know, you're not reiterating board policy. You're reiterating your sort of beliefs or whatnot.
I know Sandro has his hand raised, B. I'm just,
I can't, how do you see him
Yeah.
all? I only see what you have. It's so funny. I must have an iPad that just doesn't allow me to do
Yeah,
all
on
that.
the
Is this the
iPad, I
view
think
at
It's
all?
your view.
Yeah, you have to
Yeah,
click on the
it's
top
weird.
right. There's like a little.
No,
Yeah.
I did, but I just don't have it. Go ahead, son.
Really?
Yeah, I was gonna say, you know, it's interesting. I completely appreciate what Seema's saying, but I'm challenged with the other, the alternative. So if we were to remove which conflicts with any in any respect with positions adopted by the board, for example, a lot of resolutions were adopted by this board before probably any of us were born. So I don't have any reference to any of them. So I cannot say like in 1968, after the board was first formed, they passed this. I can't do that. But I think the intent here is if I'm a committee chair or a board member or whatever I might be, to not go to another board or to an agency and maybe be recognized by that agency or by a member of the press and state a position which is in, you know, direct opposition and somehow give others the impression that the board position was different than what it was. I think that's the intent here. And I don't know how to effectively do that, but I just wanted to make sure that that was said out loud so we can think of, if there's a modification here, what would it be? Maybe not just which conflicts, but something that brings that in line.
So I actually, Sandro, think the word I agree with you. We don't know what happened before we came on the board and stuff, but you really would be talking to a current resolution, basically, if you're talking to agencies and stuff. And we do
Yep.
have all the resolutions, and I would hope a board member, if going to speak, would make reference to it. It's retrievable. I think the word conflict is very significant here, but I would say we should circle it and come back to see if there's anything else that we could do. But it is certainly important, if you're going to say something different than the resolution, that it's your personal opinion. It's,
Mhm.
you cannot really
Mhm.
claim to be a board member.
If it's about the resolution. Yeah.
if it's about the resolution, absolutely.
We need
I
to
mean, we could
clarify
talk
that.
about,
Yeah.
we could talk about many other things.
Well, I
Mhm.
think, yeah, I mean, I wonder if it's just to say, in the event that a member speaks about a resolution in front of a
Yeah.
governmental body, then the rest of the sentence, then you can't conflict with what the board has already passed. Does that make sense? Like in this isolated
instance, yeah.
scenario, this is how you should respond.
So why don't we highlight that and we'll come back with language, okay?
Yep.
Okay. Go ahead, Seema.
Okay, just looking back at the notes from the Airtable and stuff to make sure I'm not missing anything. Okay, so the next one that I have comments on, so letter E, the comment was, should we have hyperlinks to some of these documents? So obviously the Constitution, maybe the Constitution for the state of New York, the New York City Charter. Should we just, if this document is online, should we just make it easy for people to find this content?
Are you saying a hyperlink in the document itself, or?
Yeah, in the bylaws. And I think specifically the comment was about the New York City Charter, because people might not know what that even is, separate and apart from, the Constitution for the state. And yeah, anyway, just an idea. We can discuss it. We don't have to do it.
Well, I think it would be, I mean, as people with technology, it would be easy to do a hyperlink. Am I not correct?
Yeah, you're right.
Yeah, I would just recommend then that we actually host a copy of the charter on our website and not refer to a page that will break when Do It makes a change, and then our bylaws will be broken.
Okay, that's a great idea.
I'll put
Voice of experience.
And then the last comment that I had for I'm sorry. Any other comments? Sorry, go ahead.
On that clause, I don't know if this is somewhere else, but I don't think it is. Who is supposed to be administering this oath? And should it be specified here?
It's the chair.
It's the chair.
Well, we often have
Or the borough
the
president.
borough president
Yeah.
or an elected
Borough
official.
president
or
so,
chair.
Yeah.
Yeah.
We could say the chair can do it, but then can designate someone to do it. Because I think the first time we did it was when I did it, right? Because we never used to do it. But then it was like, we should do this.
Yeah, I don't remember.
I think, yeah.
Doing it
It's
for a while.
yeah. I think I may have done it, and then like somebody who was the VP did it the
Yeah,
next
I
time.
think, Mark, this can also be done by any officer of the board.
I did it once. When I was still working at the borough president's office as your liaison, you guys had once. I remember that.
Yeah.
Yeah. Gail did it then.
Yeah, we would often, if the borough president attended that meeting, we would definitely ask the borough president to do so. But I think we've also had a council member when the borough president wasn't there.
Yeah.
Yeah. So let's leave this open, because I think if you can get the highest political person to do it, it's great to do that with new people. So I leave it open.
If I may offer something there, it probably doesn't make much of a difference who does it, because this oath thing is actually a thing, but you have to file the oath with like the city clerk, and you have to pay a $9 fee to file it. That is like the official taking of the oath for a community board member. Just sort of saying it at a meeting is just ceremonial. It doesn't actually have any effect.
I would argue that ceremony does have effect, but I understand. I understand your point.
So
it's fun.
EP's office actually.
I think the ceremony is very, very important.
No, I'm not saying don't do it. I'm just saying, just so we're clear, the ceremony itself is nice. It doesn't actually have any legal effect.
It's very symbolic in what you're attesting to.
Yeah. And
I actually don't think my cohort ever had the ceremony.
Oh,
by the way.
We didn't do it during Zoom because having people sort of all speaking at once on Zoom is not easy. So yeah, the last time we did it was at an in-person meeting. We have not done it during the Zoom era.
So Maura, you're right. You raised a number of questions before about what we've been in violation of, and You're on target.
We should figure out a way to do it.
Well, no,
Yeah.
Because although you and maybe some lawyers don't think it's important, I do think there's a lot of importance with having a member raise their hand and be initiated, as it were, into the body. I think that there's a lot of gravitas there. So I will figure out a way to do it on Zoom if we can't do it.
I didn't say it wasn't important. I just said it just wasn't the legal way to do it. And then there's like a sort of.
But
Yeah, the raise hand function.
yeah,
Yeah, you raise your hand.
Yeah.
So I think, Jesus, we're gonna give you an action item to talk about doing it. If all our new board members were not doing it, I think they have the most difficult thing, the people who came on during Zoom, because we don't have the interaction. We didn't do some of the things. So I think this would be nice, especially if we're going to continue on Zoom for a while.
Mm.
So that's not a
Jesus.
bylaws action. That's just a suggestion the other way.
Yeah.
Okay.
I'm sorry, what was the action item?
The action item is to figure out how, with the new members that came on while we were doing Zoom, to administer the oath.
Okay. I mean, I guess the easiest way to do it would be to everyone stay muted, and then the person administering the oath says the oath, and then everyone at home speak it
Just
out.
raises the hand.
You know what? It is cacophonous, I would agree, but it is in person as well. So I don't know that it's terrible that we're all out of sync and that we're speaking over each other. I think that it still does add some of the ambiance to it. So for at least that portion of the meeting, maybe we
try it now. You can try reading it out. It's okay.
I've done it. I've done it with like 100 people before. I've attended virtual graduations where we had all the graduates do so in that manner as well. So
Sure. Yeah. I mean, yeah, whatever.
I think it's cool.
Yeah, because Kyle asked me about this when because he's the first chair that we've had during the fully during the pandemic. And I just told him sort of like the official response is like pay the $9 city clerk. That's technically the law, but there's no penalty for the law. So that's why the VPs is like, just don't do it. Technically, every time a board member gets appointed or reappointed, they need to go to the city clerk and pay the $9 fee and sign the oath. But since I said, it's weird on Zoom, so you do it if you want, and because it doesn't have any legal effect, but I can see how the ceremony is lost and folks like it.
I'll petition Kyle.
Okay,
on the committee's behalf.
I'm giving it to you, Sandra. Okay. Seema,
Although no resolution was passed on this, but I'll still petition Kyle on.
This is not, it's part of the bylaws to do it, so that's what you're doing.
Yeah.
Okay. So Seema, are we finished with the first section, and does anyone
No.
else have any other comments?
There's one more,
Sure, go ahead.
and it's the last letter F. I'm proposing to move it up. It just feels like weird being down there at the tail end, because we talk about, committee members and stuff like that. And we never actually, just use the term chair. So my proposal is to move it up, but up for discussion.
Move it up to where?
Probably after letter B. There's a whole, section for the chair that's like later. Trying to see where it is.
It's right after the oath.
Yeah.
So I guess I have a copy, maybe I'm using a different copy of the bylaws, which has the chair is discussed first on how you use the chair or chairperson. And then you go into the community board members, specify authorized to represent the board members. So I guess I don't see where we need to move that up. Anyone else see where Seema is going?
1F currently has the clause, the term chair is to be used in the bylaws to describe the presiding officer of the board. Any individual elected to the office shall have the right to use chair or chairperson. I think this is where it was originally, roughly. I don't know why it would be out of order in your version, but I know originally it said chairman, and we struck that gender inclusion for no one was using it, male, female, or otherwise.
So you're, sorry, so Sandra, just to clarify, you're saying on my version, it's in the wrong place and in.
No. I
Bee's
think B was
version-
saying that she had
Oh.
it in an earlier version than what's on the screen. So I'm not sure which version she might be seeing.
Yeah, I must have an earlier version because I wasn't tracking with you, Seema.
Okay.
Okay. If no one else has any objections about moving it, why don't we do that?
Okay. 1B is what you said, right? Is that what-
So it would be the new 1C.
the new 1C. Okay.
Thank you. B, should we keep going with my section, which is section
Yeah, I
9? Or
want
do
you to
we
go to
want
the
to
next
do?
one, but I just want to make sure that no one on the committee has any other comments on this first section.
I'm not on the committee, but I do have two quick things, if I may.
Sure.
In 1A, recommend changing the word abstain to something indicating not entitled. Because from a procedural standpoint, there is a difference between abstaining and not being entitled. I know there's a lot of abstain for cause, but that's not actually, members say that a lot, but that's not actually any choice on any of the ballots we give, or, you know, it's not mentioned anywhere in the bylaws. I would recommend saying something like, and shall not be entitled to vote on such matter, or something like that. That's a recommendation.
So Jesus, refresh me, what does it say on the ballots when we vote? It says in favor, not in favor, and then the next two say what?
Abstain and not entitled. Nowhere on any ballot would we ever put abstain for cause, though members use that phrasing a lot.
So, but this says abstain, okay?
Yes, but as for from a procedural standpoint, to abstain, especially since the bylaws here indicate the CB6 bylaws indicate a members present approach to voting, abstain is tantamount to a no. And if you're not entitled, then you're just effectively ignored for that vote, and then the threshold for passage would be modified down. So it does matter whether it's abstain or not.
Sandro. Ooh.
So I think that language actually comes from Robert's Rules of Order.
That's where I got it from, yes.
Yeah.
I did my research because a member had a question about whether an abstention counted. And so I had to research it, and that's why.
So
what's the language that you're suggesting?
I would suggest something like, and shall not be entitled to vote, or shall declare themselves not entitled to vote, something like that.
So, but entitlement, so the paragraph that I'm reading in Robert's Rules of Order, I'm going to try to paraphrase, actually says it's entitled right of abstention. And abstention is what one does when they are not entitled to vote. And not entitlement to vote is just the, are you eligible to vote? At least the way I'm reading this boring paragraph here.
In the bylaws, it says that a member needs to be present and eligible to vote. I took that to mean there's an eligibility factor. So that's where the entitled, not entitled comes in mind.
So
why don't we highlight this issue of abstain and put a placeholder of entitled and not entitled, and let us take a look at that, Jesus.
Sure.
Yeah.
Okay.
And then lastly, in what used to be, now the letterings are all a little off, but what used to be 1D, where they're talking about the chair is the presiding officer of the board.
Right.
Perhaps indicating in that third sentence, this provision shall also apply to, it says vice chairs and committee chairs. Maybe we can indicate in there board vice chairs, since this is written, the committee vice chairs have been put in here, so that they're now in here. They never used to be. And so that way, just to be clear as to what kind of vice chairs you're talking about. put in board vice chairs.
Sorry, I don't see that.
Yeah, where are you? I'm sorry.
Scroll down.
Yeah, I have it on mine.
Yeah,
To what section should I scroll to?
the lettering of the sections has been modified in this version. So,
Oh, you're right, because SEMA, before I hit track changes on, I think SEMA was
yeah,
Yeah, so it used to be the 1D.
yes. So whatever that is now.
Okay, so that's E, I think now, because I think you added an
Yeah, I
Yeah.
added, yeah.
I'll
So
revert that after maybe, but what was the language again? I'm sorry.
I would say where it says this provision shall also apply to, and it currently says vice chairs and committee chairs. I would indicate board vice chairs, just to specify that, because other parts of these bylaws talk about committee vice chairs, and just to be clear.
Okay,
Okay.
so it's the new letter, just, Sandra, I think you and I are looking at the same. It's the second half of F.
Am I,
Okay.
oh, yeah, it's down here, right? Okay.
Yeah, which got.
Oh,
Just put the word board in. I think that clarifies it.
Yeah,
Okay.
board vice chairs.
So Adam, Maura, Mark, Sandra, anything else on this?
I think that whole paragraph, Sandro, that you were just
hmm
touching needs to be cut and pasted up with the rest of that clause.
So here's what's happening. We've got track changes on. So track changes does this weird thing where it moves things around. There's not a big blank spot normally here. It's just because of the track changes. But you're right. This paragraph is the continuation of the one on the page prior, right? So this chairperson, comma, continues here because of the track changes. It's been shuffled around. It'll be fixed when we consolidate all the notations that I previously made and that we're making tonight.
And might the committee want to consider perhaps putting in their, perhaps a provision that members should be writing minutes? I know it was mentioned before, sort of, it's been, and Sandro mentioned this in a previous meeting of this committee, that it's the practice of this board that the members are supposed to be writing committee minutes. And even though we've gotten to a sort of shorter template for writing the minutes, it still continues to be a problem. I'm sure all of you have seen at one of your committee meetings where the chair says, we don't have anyone to write minutes. And then there's this awkward 30, 45 minute stare until someone,
Yeah, so I would not do that. That's an operating procedure, not a
Okay.
bylaw procedure.
it does look like Ann Seligman requests the floor.
Okay, Anne, last comment on one?
Yeah, actually, first of all, I put in the Q&A, I completely second what Sandro said about the cacophony of saying the oath together. I think it's a really worthwhile exercise, especially when we're not doing anything else together. I don't know if I'm the person that Jesus was referring to. I had put my comment about the abstention in 7B, in section 7B. I thought that was the place to clarify the implications of for and against. I hate that we have this like just abstention, like it doesn't mean anything. And, abstention for cause is like, you're not entitled. Like you are, you have an interest in a business that has, that has business before the board. You can't vote for that. You are recusing yourself for cause. Otherwise, you're just saying no, but you kind of aren't. And I think I just really wish we would clarify that. And it's like something that's been a pet peeve of mine for years on this. And this is one where I'd be particularly interested to kind of hear what other community boards do, because I don't think we've found the best way.
Yeah, so Anne, you don't believe when you look at what other community boards have in writing. So I don't think that's, even though we did the research, there isn't a lot of good things that come out of certain places. Having said that, I think we parked this whole thing And I think we'll come back to discussion, and we will come to 7 and see if that's appropriate there.
Okay.
So let us deal with that as a marker, and we'll come back to it. Thanks for the comment. Okay,
Sorry, before I move on, the new 1G, which is up on everyone's screen, talks about the fact that chair and board members cannot use stationary or electronic signatures that identify themselves as CB6 members. I have seen, and including myself, identify myself as a CB6 member on my LinkedIn and on my resume, and a few other places like that, including my bio. So I'm not the only one that does it. I've seen other people in our community board. Oh, am I frozen? Can you guys hear me?
No,
No,
we
we
can
hear you.
hear and see you.
Okay, sorry. Great. So I'm not, is that really what we're trying to get at? Because I think that that's a violation of the bylaw.
so I don't look at it, I mean, I have it in my bio as well.
Yeah.
And I actually had to get authority to sit on the community board from the US government. So I never viewed it as that. I viewed it more in correspondence, because that's what it's talking about. So you're not doing correspondence out where you're
It doesn't
sending.
actually, it does not say correspondence.
It says in correspondence.
That's
of
the
any
next
kind.
sentence. Yes, that's the beginning of the next sentence.
So that's where I'm focusing on explaining that in the next sentence. I don't know if anyone else has issues, but I think it is absolutely not a violation to have it on your bio.
No.
No,
I think maybe we're just putting in correspondence at the very beginning of G, comma, with the exception. That might clear it
I
up.
get, yeah, or maybe an official correspondence or something. I see
Mhm.
Sandro has his hand raised as well.
yeah, I just wanted to add some history to this. I think I know exactly where this came from.
Okay, go ahead. You're our
Um,
history person.
Apparently. So there was a member of a board in the not so distant past that was in real estate. And after this person joined the board, had specific cards printed out in a manner that when they met with potential clients, they were also saying they would be providing an expedited service through any sort of board modification that might need to happen because it was commercial. And I think that was the problem. And the council basically said they weren't in any direct violation of any rules or regulations in doing so. And I think the reaction from this board was to add something to the effect so that council could step in and take action, removal for cause sort of action if someone were to do that again.
So if by moving that sentence up at the beginning, does it help us in any way?
Oh, like flipping sentences?
Yep.
Yeah, because then it makes the whole thing about correspondence of any kind.
It's just a vague sentence.
Mhm.
Like it doesn't mean anything if you actually read it. It says board members shall avoid using identifying information, which is bizarre. Like I have to use my name and my email, that might suggest a potential conflict of interest. So I actually don't even understand what the sentence is trying to communicate.
Well, I actually do understand what it's trying to communicate because having dealt with conflicts, you would not identify yourself as a community board 6 member if you're writing about something that's not in your official capacity on the board.
Well, it actually specifically says board business. So that's negating what you just said.
No,
actually
but
be.
people expand what they consider board business. Okay. And
Yeah, but
so
this says that this is related to board business.
yeah, but people expand that totally.
Well, I think it's also complicated by the fact that we live and work in the district. So we often have an intersection between our personal business and the board business. Yeah.
Yeah, I'm comfortable leaving it as it is or moving it up. but
You
I
know,
would not take it.
I would just kind of, and Jesus might be able to clarify this as a more formal city employee than I ever have been. But for example, as an employee of the city, one cannot use their official city email to contact their landlord and request, a rent discount, right? Because there's a conflict between the imprimatur of the city agency being associated with you as a personal citizen there. So I imperfect again, but I think there is something that we should, kind of echo, because board members are not quite employees and don't have the same sort of training or the same sort of understanding of that. Jesus, is there some language or something that you think would be aligned to that, just to help prevent us from stepping afoul of the intent of conflict of interest that maybe we can leverage?
That particular example, that rule about not using your position to derive personal gain already is part of the conflict of interest law. So a member should not be doing that anyway, even if it is in the bylaw. It's not in the bylaws, because they'd be while they're not a city employee like me or community board staff are, they are city officials, and so they're still bound by that. That said, yeah, I do kind of see where Seema's coming from with this. It does, in just reading the whole correspondence related to board business, to me, it says, like, for example, if you are the Parks Committee chair and you're reaching out to the Parks Department in an email, your signature cannot say Parks Committee chair for CV6. It has to just be like your normal name. That is, but I can also see how it should really be saying, in addition, like, you can't reach out to your landlord saying chair of Community Board 6 to try to intimidate them or anything like that.
Well, but the first sentence in the original order does say members specifically authorized to represent the board by the chair. So if a person has been appointed as the chair of parks and they are communicating with parks, they have been appointed and have been granted the condition that they can contact parks, I'm sure.
Right. No, they can. They just, according to what's written here, and again, there are a lot of things that are in the bylaws that don't make sense to me. Right. This seems to say that they can contact parks. They just cannot put chair of the Parks Committee in their signature. So I don't have quite the history that you do here. So I don't know where this would have come from or why.
I think I just got called old.
Yeah, you got so, no, I'd rather call you the history person.
Your experience.
Yeah.
We are
So
archivists.
why don't we highlight this sentence? Okay.
Yeah, I put reference like COI policy instead. I mean, I think we should come back to this. I agree.
Yeah. Okay.
Yeah, thank you.
Okay.
All right, so happy to move on to number.
So why don't we move on to the next article?
Was it 5?
I had number 9 as my next one.
Which is, you had number 9, which relates to members in one way. Go ahead.
Just waiting for it to scroll down so we can all be on the same page. No worries. Take your time. Okay. So the first clause. So I'm looking through the comments that I received from the Airtable, and they're not that many. So what is an excused absence versus an unexcused absence? So that's the first question that we have there. I don't know if we want to define that or if we have an official definition for that. It might be worth.
Oh, there used to be. Is that gone?
There was one in there.
There used to be a definition.
Yeah.
That doesn't exist one now because it was
no, it's in another section.
It's another section. Okay. Do you know where that is, or is there? What is the military? I wanted to say military's in there. I know that.
Yeah. Search for the word. It is. Let me find it.
I got it. C, it's attendance and excused absences of board members shall be properly excused for the following reasons: military service, jury duty, personal illness or death in an immediate family. I corrected the missing space there, and attending to board business at the request of the chair.
Okay. I do often, I mean, just anecdotally, I do know that people miss meetings because they're, still working or, for example, traveling. And we always, I know that in, other committees I'm a part of, we do say that that's an excused absence. I don't know if that actually is or not.
Seema, that has become the role of the chair and stuff, but when I joined the board, it was not. So if you were had to go on business or stuff, it wasn't considered then an excused absence.
Okay, because B, you said at the top of this call, so-and-so is excused because he's
Yeah.
traveling.
'Cause
So
I
is
have
he
always
excused
felt-
or not?
I have always felt that we are volunteers for the community board. We are all professionals. Periodically, we are tied up with business. So that, to me, is an excuse. And I followed what the board has done because it's really liberalized the whole thing than what's here, okay?
And
Go ahead.
yeah, no, I think there's also been some other like whether or not it's a regular meeting or I mean this other language here about whether it's a rescheduled meeting. It's a good point. Should we be adding business? I guess the two corollaries are or at least the one corollary is what happens, if someone's now permanently working from Taiwan, at what point does at what point does that completely conflict with their ability to participate in any board business? And then, of course, the actual ramifications are very rarely do people get expelled through the board or through the borough president's office or anyone else because they're failing to attend meetings unless it's excessive, like 6 months, in nature.
So I actually think, you could have a business, but you could have that they could be rare. Okay.
I would argue we should add other categories, like what if one is pregnant or, that's not an illness, but there's some legitimate reasons why someone could miss a meeting if we're going to actually try to enforce this.
So I have only seen this enforced twice, okay, since I've been on the board, and that's a long time. I don't know, Sandro, Mark, have you seen it more than twice?
I remember once when it was unpleasant. I was
In
15 years
2005,
ago.
I actually was doing some research on another topic, and I found in 2005, there was a series of 4 resolutions that were put before full board for 4 different people with bad attendance. 3 of those resolutions failed, and one of them passed. So that one person, I imagine, was booted off. It was way before my time, 17 years ago. So
even before my time.
Yes.
Make me feel old.
Yeah, so that's the last time that I could find any evidence. And if you want to see, that resolution is on the Reso tracker. You can just search for removal for cause, and you'll find, I don't know who the person is that I don't recognize.
Well, and actually, when I became chair, I asked several people to step off the board. One of them didn't know he was on the board for absences.
Oh, wow.
Yeah, I was like, I'm not on the board. I'm an elected official. It's like, well, here you are. It's like, what? So no, I'm not on the board. So off.
But and again, what you guys decide to add as what's allowable to be excused, that's your own thing. I don't know that I have any great thoughts about those. Although what Sandra was saying, yes, if you add so many things, then everything will be excused, and then it could just be that people never show up. But it might be good to do some sort of to hone in on that, do a process, because this has been something that the board has not really been willing to handle.
And Jesus, I was going to ask the question about this before Sandra goes. So, we take the attendance, we do all of that. I don't actually know of, even when we've had Zoom, because it's been different and most people have been here. But do you guys actually do a summary that you share with the executive committee now or stuff that actually does that? Because if you look at it, and you're absent for half of the regularly scheduled meetings in any 12-month period. That's pretty amazing. That goes to Taiwan and doing the meeting, Sandra, which you shouldn't do. So what do we do? I mean, we have it in here, but what are we doing to even look and enforce it?
So we have been doing summaries, but we had been sending them not to the executive committee, but rather to the individual committee chairs and the board chair of each respective committee. But this past year, which things got away from us and we didn't do it this past year because in previous years, we'd get oh, thanks, this is nice. Or if we got a response at all. So we were like, okay, we'll keep it for our records. We have those records, but we didn't this year send them out because it didn't really seem to matter. And very rarely do people get booted off. But no, even now, according to what the bylaws and the charter said, there are people who would be in danger, who could be removed for cause. No, I mean, since the board hasn't really taken it very seriously, the office hasn't bothered to really take it seriously. But we have the records. We keep the records very well. We just don't.
I'm sure you do actually. I know in the past, and I don't think we should do this again necessarily, but I'm thinking along the lines where in the past I recall, like at the end of the year, there would be in our packets a kind of summary of attendance and voting. So it would be like a month by month. This month, 1A, 2A, 2B, C, that sort of thing. And it would show the voting record of each member. I don't think that that's necessary, but it might be interesting to have a view that shows voting and participation in that sense for any sort of review by the chair or others, whether or not someone's been a competent or an active member.
We do that now at full board for attendance. In the full board minutes at the very end, it starts with January and it goes through the end of the year. So by the time you get to December's minutes, all of the attendance for that year are there. There were some calls to just have it a rolling 12 months, but just because of the way we keep records, we thought it was easier just to do it, build upon year by year. And let's be frank, not a lot of people read the minutes, so that's that. But we have the records just in case, because the Freedom of Information Law requires us to have these records.
Of course.
So we have 3 different types of removals. One is a public member in this section. One is the borough president can remove, and one is the majority of the board, okay? And so my question is, if we deal with reality as to what the process is or not, should we really be focusing so much on this and maybe leave it at the borough president's or level as opposed to the board? I think it raises a lot of questions in my mind. Having a rule that we don't enforce or use, what's the purpose of the rule?
Do we feel that this is a problem though, that we need to sharpen the pencil on? I mean, is it just that we have a bad rule that's not being enforced and therefore it's useless? Or is it also that we want better attendance? I mean, what is the goal, I think, that we should be driving to?
Well, personally, and now I'll go to the committee, if you're a member of the community board, you need to attend meetings, okay? And you need to be an active participant. Or you take yourself off the community board, which a number of people have done. As their business has overwhelmed them, they've actually taken themselves off. But to have something as specific in the bylaws and then just never use it or have the intent to use, I just think makes no sense. Okay,
Yeah.
But anyway, that's just my own feeling. I'm going to turn to Seema for this whole subject and then any other board members. Seema?
No, I mean, I agree with you, B. I think that's just what I was trying to raise. Like, what if we want to define these things? I mean, I know that we defined them earlier on, but if we want to expand the definition, then I think this makes sense to have, especially if we want to expand the definition to include, 1 or 2 additional de facto categories. Like, for example, traveling for work. That could be a category. I'm just talking out loud. That just sounds like one of the things that committee chairs, are allowing. So I think if we want to expand with things that are just kind of happening in practice, then I would keep this section, would be my recommendation.
What are the thoughts of the other committee members? Mark, your thoughts?
I kind of think, it isn't really a problem now. We just probably should operationally focus on it to see if it is a problem. Like, hey, see, you should have the information. I know the borough president supposedly looks at everyone's attendance and thinking of being reappointed, but maybe we leave it as it is. I think a lot of people, when they have something to do, they say they're ill and they're not. They understand that's.
Yeah,
I mean,
no,
there was a joke on the board, but I won't go into it. Years ago, from a former member. So maybe we just leave this as it is, and maybe we look into it to see if we do have a problem. If we do have a problem, then it should be addressed.
Yeah, I mean, I would just ask one thing. I mean, I'm not opposing changing or removing it or anything, but we're expanding. I just would think that this might be something we do want to reach out to the borough president's office, because I do recall running into several situations where the council was very limited in what actions they could take because they didn't have a particular regulation or rule that anyone was technically in violation of. So if we kind of remove the whole concept of removal for cause because of a reason, then we probably will never have that, even though it's a rare thing to begin with, because it's a very political matter. And I think, any elected official or anyone is not necessarily trying to, get the scorn of whoever that member or whoever that constituency might be. So, just a thought. I just want to just validate that there's not some rationale that we might want to keep something there.
Adam, what's your thoughts?
I agree with Sandra. We have to have something, it's even in a very rare case, it's just something that we have as a board in case something needs to be executed on.
Okay, Laura?
I agree too, and wonder if the language just actually becomes less specific and we say absent for a reasonable cause.
At the board's, at the chair's discretion.
Yeah, exactly.
Yeah,
That
that's
makes
a good
sense.
idea.
Yeah.
I would do that because it makes sense, as opposed to if you enumerate all these categories, in essence, you're saying that.
Do we want to leave them as potential but not completely inclusive, or do we think we should just strike them all?
I personally, and I want to hear other people, I would strike them.
Wrong window.
I agree.
Yeah.
Because that's what we're doing. I mean, that's reality.
It is, since the office keeps the records, I can chime in here. First of all, I've heard a lot of questions about whether this is a problem. Is this a problem? Not really. At full board, we always comfortably have quorum. At committees, it's more of a problem, but it's not, we've gotten better about not having quorum at committees because of attendance. As far as the borough president's office, I mean, we don't know how this new borough president will be. My experience with the old one is that they will not, they are trying very hard not to remove anyone. And that when we had a member who just sort of up and moved away to do something that was not CB6 related and didn't even tell us and started missing a lot of meetings, the chair at the time wanted the borough president to remove this person so as to avoid any ugliness, any public ugliness. That the borough president would not. They were like, the ball is in your court. If you want to remove them, you put them up for a vote and you do it yourself. So that was the posture for that borough president. I don't know if that will be the case for this one, but it is unpleasant. So I can imagine that if they don't have to do it and they don't have to be the bad guy, they won't. There have been plenty of other board members who have had bad attendance for years, and they kept getting reappointed, either because they were not straight up, borough president appointees. They were recommended by their council member. So, or because maybe the borough president was convinced that they would improve their ways or whatever. So it's hard to get rid of them. And as we saw from the example back in 2005, just even if you put someone up for a vote if they have enough friends on the board, if they make a good enough case for, you know, extenuating circumstances.
Was
they
it 3 or
still-
4? Beat the rap.
Yeah.
So, yeah,
So I
Well,
would
no.
say that, I mean, I think we should make this very general. You know, I think we should take out the reasons. We can go the other section, make it very general. And if we want to have a provision, but I think having a provision and no one will implement it is, to me, makes no sense. You know, bad laws on the book that you're just going to avoid makes zero sense, okay?
I will say
But I
from-
don't know if we need it there for political reasons.
I will say from an operational point of view, because the fact that it's spelled out helps the office, because even though B had said at the beginning that the member who's absent today is going to be excused, we were going to mark them absent because in the bylaws, it delineates which are excusable and which are not. But if all of this goes away, if all this specificity goes away, it needs to be clear who makes the call on whether a person is excused or not. And otherwise, I don't, because I don't want the office to be having to go back and forth or guessing, or, you know, at some point I even wondered why have an excused absence at all if even absence doesn't necessarily seem to do anyone in. But I would just say from an operational point of view, make it clear how the office is supposed to act, because otherwise it may.
Yeah, how would the board remove someone who doesn't attend after a year if we don't have something to the effect that there is an attendance requirement in the bylaws?
So I think you could have something in the bylaws that says one has to attend at least 6 of the 12 meetings. I mean, you could have a minimum requirement and not deal with excuses, okay? Because if I say to you, I'm ill, do you know whether I'm ill or not? I mean, I can put up my
No.
hand right now and use that as an excuse. But you're not going to ask for doctor's notes. You're not going to ask for any of that. So either you have a requirement that you have to attend X number, and you know that requirement at the beginning. You could do it, but I will tell you this, even with that, I think the ability to, I mean, it's good to know so people think about, well, I need to attend the meeting, okay? But to actually get rid of someone, Sandra, you know, I remember that debate. I didn't remember it was in 2004. That was a very unpleasant
Ugh,
evening, okay?
that was tears and awfulness.
And,
Yeah.
and the fact that the board member themselves wouldn't say, no, I couldn't, wasn't here, and I would just leave. And it became that type of a situation. And in essence, the board really doesn't have teeth because of that, as Sandra said. So I've always found this problematic, but you could set a minimum without excuses. You could just actually have a minimum that you have to be in 6 out of the 12 board meetings and 6 out of the 12 committee meetings. You have to attend 50% and not have excuses. There's another way of doing this.
The charter has a requirement. The charter says that a high amount of absences within a 6-month period. It does not define high, so let's just assume it means more than 50%. But the charter has one. But also, and this is very tricky. Like, I don't envy you guys this task because, you know, I have seen, I think it also depends on the member. Like, for example, leaves of absences. When we had a member who took a leave for a professional reason, we've had a member take a leave for like you know, paternity, maternity stuff like that. That's not in the charter. That's not in the bylaws. Those are absences. But because these members were really high functioning and really well liked and, you know, really good members, no one said anything. The members who are not as good, let's face it, there's a wide ranging quality among members. You know, some are good, some are not. Those are the ones that get that, you know, that people try to remove. So it's tricky.
All right, so let me see what the committee wants to do with this particular section that we're talking about. How do we want to handle it? I'm going to ask each one of you. Sandra, how do we want to handle it?
I'm putting together in real time, I guess, some like potential change based on what you were saying. But I think you're probably on the right track of maybe just, and don't wordsmith it just yet. I'm just like doing it out loud, and now you've distracted me. So it's probably even worse than it'll come out. But I think you're probably on the right track of maybe removing specific things and allowing the chair to just decide, is it a paternity leave? Is it someone that is actually not contributing even when they're here? You know, like I think there's a lot of factors that maybe our leadership that we've elected and we've appointed, we should vest some power in them in deciding what's appropriate and what's not.
All right, Adam, what do you think?
I'll agree with that, and also like your idea of the sort of minimum threshold as opposed to, you know, different meetings. So you should attend 51% of the meetings as opposed to if you miss X.
Okay, thank you. Maura?
Yeah, agreed.
Okay, Mark?
Yeah, agreed, but I think we've got to make a chair of the board for full board and chair of a committee for.
Yeah, absolutely.
Yeah, but 51%, I still think it's kind of low, but you know, that's okay.
Well, given what you went through, even that is going to be hard.
Yeah, but you know, the chair can just say to somebody, "You're not showing up. Want to be a public member, or you're not showing
Well,
up."
see, I don't understand. If someone said that to me, you know, you're not welcome anymore. Why would you want to stay unless you're building your own personal agenda?
And people did that when they were asked. They actually said, "I'll go public. That's okay."
Yeah.
We had a few people who were wonderful who went to public.
And Sima, since you were dealing with this, what's your thoughts?
I think we should keep the removal for cause, and I agree with keep that I don't know if that's what we're discussing. I'm losing the thread a little bit, but
Oh, you're right. I'm sorry. I went
keep the section that has the removal for cause, but have it refer back to the previous section that Sandra was just editing, and maybe make it more broad. I think like Maura was recommending too.
Okay, so why don't we play with the language, Sandra? I'm going to let you not interrupt your thought process.
No, I'll just, let's continue on with everything, and but basically I think the intent that I will try to put in there is just, they should notify the chair beforehand. So I think it's probably a good idea that we don't, like 6 months after, try to get someone to retroactively excuse the person for the last 6 months without them, notifying the absence ahead of time. And of course, leave it to the discretion of the chair of the body, not the board, but the committee or
Right. Okay, I'll let you go with that. So
the next section, like the next sentence within that section, sorry, B, were you going to say something else?
No, I'm going to say to you, go to the next one.
Yeah. So the sentence that begins the first part of 9A, the second part of 9A, sufficient cause for removal should include but not be limited to a conflict of interest that is incompatible with board membership. I don't want to open up a can of worms, but I guess I just didn't know what that specifically meant. And I don't know if we want to clarify. A question for the group.
That's interesting.
I'm gonna guess incompatible being that I live in Taiwan, or like, to use that same scenario again.
But like in a remote work environment, like let's say you do live in Taiwan, but your company is based in CB6, right? Because you can live, work, learn, or pray.
Well, you have, you have, actually, you don't even have to have any of those. You could just have a significant interest, I think is what the charter says. But but you have to work in the district then. I mean, if that's the rubric, right? So, but no, that's not really a conflict of interest. What is the specific conflict of interest in votes taken? Oh, no, I'm sorry. This is just, I am, if I fail to abstain for cause, or not vote because I'm not vote because I'm or disclose that I'm not entitled to vote, I should say, to Jesus's earlier comment. I think this is just if someone has a conflict of interest and they continue to vote, that is a violation of our trust and of course city law, I think, or city code, I should say. So I think that was the
Wait,
intent here.
Do we potentially just remove the sentence or remove the part of the sentence that says incompatible with board membership, and then just go, but not be limited to failure to disclose a specific
Yeah,
conflict?
yeah.
Yeah, I think that's a good modification.
And it's unnecessary and confusing.
Right.
Yeah.
Mhm. Yeah, because it's a conflict.
Right.
Yeah.
Okay, and then the last 9B, I felt like it was a bit repetitive. So it says that a public or committee member may be removed by the chair. And then at the last part of that sentence, and only with the consent of the chair of the standing committee from which the public member is to be removed. I think we can just reference the chair once. A public member of a committee may be removed by the chair. And then that's
Board chair, or committee chair.
Or
Yeah.
committee
Oh, yeah, chair
chair.
of the
Well,
standing committee.
Yeah.
sorry.
Al wanted
It's
to
the chair
so
of the, it's the
member.
chair of the standing committee that they're talking about.
Yeah, so the public members are appointed by the board chair to serve as a full member of a committee. So I think what this is saying that the board chair should not have the power to change potentially the vote. Because let's say there's a public member that the board chair appointed, we want to have like because the board chair appointed that person also, I think it's just like a check and balance that there's another party that thinks it's appropriate to remove them.
Okay, I see. So it's saying that the chair and the committee chair, says the chair of the board and the chair of the committee
Yeah.
both need to be in agreement that this person should be removed. Is that?
So
That should
there's
be
an easier
clarified.
way of saying that,
Yeah.
okay? You could actually say it may be removed by the chair with the recommendation of the committee chair. I mean, that's what you're really saying.
Mhm.
Or the
Yeah.
concurrence.
Well, consent requires a positive affirmation. Recommendation is just, you can,
Or concurrence.
yeah, okay. And I could also put chair of the board in the first one, so it's
Yeah,
clear.
it's because you have chair and chair.
Yeah. So wait, what was the I'm sorry, can you say your change again so I can?
A public
Fine.
member of a committee may be removed by the board chair with the concurrence of the committee chair that the public member is on.
Okay, so do you want to strike all this language about from their appointment for a cause, including but not limited to, attend meetings and described section 9A?
Yeah. No, I would just eliminate all that. It's repetitive.
Okay. Well, it's not repetitive in the sense that we've never actually, so this is a public member. So this is the first time, this is a member, and the first A is a member, B is a public member. So
But if we're
it's a
going to go
different
back
class.
to A, yeah, if we're going to go back to A and have up to 51% and stuff, you're doing almost the same thing. You could refer back to A as to the reasons.
right. So get rid of the for cause. So we're basically just gonna remove this portion here and say for a public member of a committee may be removed by the chair of the board during their 1-year term of appointment only. No, forget only, but for cause, including as described, or do we reference then the other one? Because I think we just need to
Including as
define.
described, for reasons as described in section, 9A. And your 9A will be your 51%.
Right. So like this, right? Appointment for cause, including as described in section and section 9A. This is kind of repetitive here. What the hell is that? Why does it say 9A and 9? That's crazy. Whoever wrote this.
You're a better person than I, Sandra. Thank you.
I think I actually wrote some of this. So I think it was me, Rick, and a few others. So sorry. Any other reasons set forth in 9A with?
Okay.
And should I leave and only? Or no, you said.
With the concurrence, I threw that up there.
Yeah, with the concurrence.
Okay,
Okay, and I'll spell it better.
okay, Sima, anything else?
Nope, that's the end of my section. Thank you all for your very thoughtful
Well,
feedback and
thank you.
comments.
So I'm going to make a recommendation looking at the time that it's now, and because Sean is not here. So I'm going to recommend that we move his section 5 and 8 to next meeting, and then include Adam with 6 and 7. Although if we have, you know, what we're doing today, it will take us long as we're dealing with this to go through it. So, and then I would recommend we go to the summary to deal with the issues of term of office and the election. So I'm going to ask for us to modify the agenda that we agreed to move item 5 and 8 to our next meeting. And we will then also cover 6 and 7. Do I have a motion to so do?
So moved.
Okay. Any objection? Okay. Now, why don't we go ahead now for the chair's report. At this time, I have no additional comments. I think everyone has done an incredible job in going through the various items that we're dealing with. And I think we will probably be able to present this in the fall, the way we're going, and for the period of time. We'll have to do a lot of work to clean up. So anyone have any comments at all before we go to under old business? I'd like to have Jesus talk about what he found out about terms of office and the election. Anyone have any comments first?
There's a question from a member of the public, and there's also Anne Seligman who would like the floor.
Okay, so Anne, why don't you give your comment?
Yeah, I actually just really want to thank you guys for how obviously diligently you are working on this and how seriously you're taking these issues. I think it's really important, or else I guess I wouldn't be here either. And so I just really wanted to thank you for all your hard work on it.
Thank you, Anne. I like business process and rule process, but I have to admit, this is one of the more difficult ones for us to tackle, because you don't really know what a lot of the intent was behind the language, and so many people have worked on it, and things we do and don't do, but thank you so much. And who's the member of the public?
This member of the public wrote their question in the question and answer box.
Okay.
It is from Abdurazak Ali. They say, hello, my name is Abdurazak Ali, CB6 resident. First of all, thank you for all the great work you are doing. When it comes to rewriting or correcting the CB6 bylaws, my question is there an article that seems to be an obstacle for board members to get the job done? If yes, did you select within the CB6, the bylaws committee, those who can receive, review, and recommend proposed amendments to the CB6 bylaws? Thank you.
So I think I'm going to answer that and then see if any of the other committee members. I think, as you can see, we're going through line by line to actually see what the bylaws say. The committee that you have in front of you that you've observed are people that have served on prior bylaw committees, that have also been officers of the board, as well as newer members of the board. Because certainly while we have history, a new member also will see things as they've attended meetings and have seen us work. So the whole idea is to make the bylaws more efficient and effective, and to actually say how we operate during our meetings and our business. And I'm going to see if any other board members want to add anything.
I'll have to say, well put.
Yeah, and thank you for your question. I think you see how we're focused on what the words really mean and what are we doing in reality. And I think that's at the heart of your question. Thank you. So Jesus, if I can just go to what you found, I thought it was very, very interesting. That deals with the term of office as well as deals with the election.
Sure. I did have some charts and graphs, but honestly, in the interest of time, maybe I could just read out my remarks and then.
Yeah,
I
why
think,
don't you? Go ahead.
So we did this research in two phases. First of all, thank you to Alexandra, who went out and actually compiled all this information. I crunched the numbers, but it was a big help for have her scouring all of the community board websites throughout the city to find this information. So we did it in two phases, the other boroughs and then Manhattan. I'll speak to the boroughs first. Of the 47 community boards that are located outside of Manhattan, 26 of them did not have their bylaws available on their website. So in fact, this is only 21 boards worth of information. Brooklyn CB12 didn't seem to have a website operational at all. So when B says that Manhattan's the best, we really are. So, but these boards that did not have their bylaws on their websites are not reflected in this data. Of the 21 boards in the boroughs that did have their bylaws posted, 48% of them were Brooklyn boards, 29% were Queens boards, 19% were Bronx boards, and 5% were Staten Island boards, or rather board, because only one of Staten Island's 3 community boards posted their bylaws on their website. And this is what we found. As for the term length, boards in the boroughs opted 2-to-1 for 1-year terms. As for the month of elections, there was no real majority. The top 3 months were June with 33%, January with 24%, and March with 19%. Those 3 months represent 76% of the responses. So CB6 would seem to be an outlier with our October election, at least as far as the boroughs are concerned. None of the 21 boards that we reviewed shared our election month of October. As far as month of nominations, again, there was no majority. There was a tie for the plurality at 19% of responses each, with May meeting and did not specify. I was amazed to see that several of the bylaws we reviewed were silent on some very, very important aspects of the election and nomination process. Though since June was the most popular election month in the boroughs, it is not surprising that May would be the most popular nomination month. As far as month of selection of the nominating committee, again, no majority, and the plurality went to does not specify with 1/3 of the responses. There was a 3-way tie for second place at 14% each with April, October, and other. Again, April would seem to be in line with a May nomination and a June election. The fact that there were no majorities in any of these categories reviewed suggests that there's no clear consensus among the boards in the boroughs regarding the timing of their elections. But a popular option in the boroughs is selecting the nominating committee in April, announcing nominations in May, and holding the election in June. For Manhattan, I crunched the numbers for all 12 of our boroughs boards, including our own. For term length, the preference of 1-year terms was even more pronounced in Manhattan than it was in the boroughs. Here in Manhattan, boards opted 3-to-1 for 1-year terms. As far as month of elections, there was no majority, just like in the boroughs, but the plurality was greater here in this borough. 42% of boards, 5 out of 12, hold their elections in November. The remaining elections happen in June for 3 boards, October for 2 boards, including our own, and December for another 2 boards. Strangely, it seems like there's a real split between Manhattan and the boroughs. In the boroughs, they overwhelmingly, 76%, prefer elections that happen in the first half of the year. Whereas in Manhattan, overwhelmingly, 75%, we prefer elections in the second half of the year. As far as month of nominations, again, there was no majority. First place was October with 42% of responses, which makes sense since 42% of the boards hold their elections in November. Second place was May with 3 boards, and our month, September, was tied for 3rd place with November. each of the two boards that announce nominations, each with two boards rather, that announce nominations in those months. As far as month of selection of nominating committee, again, no majority, but predictably, 42% of boards announce their nominating committees in September, which is in line with a November election. The bottom line, in Manhattan, while there's no majority, the plurality, 5 of 12, seems to be for November elections in Manhattan. Thanks.
Thank you, Jesus. Any questions of the data that Jesus just presented? So going back to the draft that we did, with this area, I was going to put two comments to the committee. One is, I think, our decision of keeping it as a one-year election, and renewed on a one-year basis seems to be keeping with the general trend in Manhattan and the other boroughs. So I was going to recommend that we stay with the one-year term. Okay. The second thing that I was going to recommend, based on our discussions and hearing the statistics of what we just did, and the fact that new board members come on in May, I think we can go to what we were talking about on the presenting the nominations in September, having October as the month for candidate forums or getting to know people, and doing the election in November. It seemed that November was the appropriate month, and it would allow new board members who come on to get to know the people, to, whether we do speakers of the candidates or we do informal type of stuff. So I think that's what we spoke about, and the data that Jesus presented didn't give me the feeling that we should do anything differently. But I want to hear from all of you what your concept on the term and the election itself. So anyone with your hands up? I could see you all now. No comments?
Technically, Adam has his hand up.
Adam is seeing. Okay, Adam.
I don't have any comments now.
Okay. Anyone disagree with the proposal I put on the table?
No, I think it's
No.
fine.
Yeah, it's a good idea.
Okay.
If
So
Stevie-
we will, we had, Sandro had it in his draft. We were talking about that, but we said we would come back and look at it. Okay. So I think we can now add that. So the month of October would be the month that we would actually have board members get to know, through whatever means we decide, who the candidates are with the election in November.
Do you have any specific language you'd like me to incorporate already? If not, I'll adapt.
I'll let you adapt. You're so good
Okay.
at
All right. Okay.
it.
He's got
Okay.
her hand raised. Oh, sorry.
Dee had her hand raised because the hand is hurting.
I
When I keep
know.
it down, it swells. So
Put it down.
even though I'm wearing a compression glove, it still has like major issues. But
Mhm.
in any event, we will get past that. So any other comments under new business?
I'm sorry, if CB6 is successful in moving their election to November, then that means 50% of Manhattan boards will have their election in November.
Thank you, Jesus. And I think that, in one way, I wish there was more involvement by the borough presidents in some minimum standards. Because after I looked at all you provided, even for all of the boroughs outside Manhattan, you really have the question of how are community boards performing efficiently and effectively, and what are the rules of operation. So I guess I'm a US government bureaucrat, and I like to see a little more rulemaking taking place. Seema?
Jesus, if it's easy, and honestly, if it's easy, could you forward what you just stated verbally? I need to see it to really connect with the data, but if it's easy, that'd be great.
I wrote it out so I can actually just paste it into an email and send it to the entire committee.
Thank you.
Wonderful. Thank you.
That would be great. And when I looked at the data that Jesus had written, it really will move you in the direction that I articulated. So I thank Alexandra and Jesus for the work that they did on it. I thought we would find more outside of Manhattan, so I first went outside, But when I saw the results, I said, okay, let's come into Manhattan and see what Manhattan is doing. Any member have any other old business or new business? Please raise your hand. Okay, do I have a motion to adjourn?
So moved.
Okay, so we're adjourning for the minutes at 8:25 p.m. And thank everyone, and I will get a note to Sean that he's not off the hook. So Adam, Sean's going to go first, and then I don't know if we'll get to yours. You see how detailed it is, but I think you need to be prepared, and then I will take the last two articles, and then we can go back to the entire document.
You got it.
Thanks, everyone. I appreciate it, and have a good next month. We'll see you at the board meeting.
Yep. Take
Thanks,
care.
guys.
Bye, everyone. Have a good
Bye.
night.
Feel
Right.
better, Mark. Feel better.
Thank you. I'll be Taco Bell if anybody wants to meet me.
Bye-bye.
Good night.
Bye.
Bye.
Bye.